Assalamualaikum.
Miam.
Assalamualaikum.
Walaikum assalam.
Welcome. Thank you for coming out. Today's lecture is titled How to Live Within Contracts and Stay Within a Common Law Venue. I'm going to begin by giving you an introduction. And we're going to talk about ancient Moorish principles. And the ancient Moorish jurisprudence principles, which are imbued in the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal and endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from consent of the governed. I'm going to explain that. That statement is read in schools all over the country. However, it is not broken down to its common element. We hold these truths to be self-evident. Inalienable rights are rights that are divine, that are natural, that are God-given. The governments, as I said, derive from the just consent of the governed. What it means is that the powers of government is derived from the people. Rights do not come from government. Rights are secured by government through the Constitution. Rights do not come from Constitution. Rights are secured by the Constitution. Most people have concepts are that rights come from government, that they're waiting for Congress to legislate rights for them. The right to bear arms, the right to travel. If Congress does not legislate these bills, statutes, laws, the rights don't exist. That's a misconcept. And that has been that false concept has been interjected into the social fiber. So you have the general public who are unaware of what rights are, what government, the limitation of power of government, are simply fooled, and as a result, their rights are stolen from them every day. So make it very clear that your right to travel, as an example, is inalienable. Meaning that someone's asked me, Brother Bay, how do you travel? How do you operate, drive? Well, you simply, put the key into the door, open the door, put the key to the ignition, and you operate the vehicle and travel away. Huh? Yeah, what did you understand? See, they're looking for an instrument, an excise tax instrument, the driver license, and they're thinking that the driver license gives them the right to travel. The driver license is an excise tax instrument that only applies to corporations for doing business in a corporate capacity, and is a fraudulent form of identification. So your right to travel, your right to bear arms, are secured in the Constitution for the United States of America. It does not come from the Constitution. So we must understand, we're talking about common law, how to live within a common law venue. And the key to that is understanding where rights are derived, where governments are derived, the limitation of government power and authority. That's very key. Now, going further, I'm going to repeat it again. We hold these truths to be self-evident, that all men are created equal and endowed by their Creator with certain inalienable rights. Doesn't read endowed by government with certain inalienable rights. So I want you to go out, pull out that Constitution, that Declaration of Independence, and examine that. Examine the words that are written there. You will not read that rights are not derived from government. So that's very key, that most people, when they read something, they're not reading it. They're not absorbing what they're reading. And we need to absorb what we're reading. We need to break down every word, every sentence. Make sure that we understand the connotation of words, the shades of meaning of words, the etymology of words, which is the origin and true meaning of words. Oftentimes, since I study etymology and I teach etymology, all right, I'm going to give you some information on how to study. And I'm telling you to read. I want to give you information on how to read, because I don't want to assume anything. We need to understand that words are colored, meaning that the original meaning of words are buried and new meanings are given to distort the original de jure concepts, but therefore put you into a negative law concept. Those distorted meanings take you out of the common law venue. You must understand the de jure meaning of words to be brought back into the common law venue. So what you do is you open up a dictionary and you go to the brackets, and that's where your etymology is. We've been taught, instructed to go to the first definition, number 1, number 2, number 3, number 4, number 5. And oftentimes those definitions are distorted, but your foundation is the etymology. You begin there, and that gives you a clear concept of the meaning of a word. So this is how you begin the process of getting back into the common law venue, by knowing how to study. So I'm giving you some instructions on how to use a dictionary. Though it's limited, it's a beginning process. And later on, I'll be doing a lecture on etymology and how to use a dictionary more effectively. I'm introducing, so I'm not going to be lengthy here. But we're going to be very clear of how to live within the common law venue and understanding what inalienable rights are. All right? So I'm going to say peace, and we're going to have a brief section, and Brother Nature will come up and continue the discussion.
Islam, family. All right, the camel back on what the brother was breaking down. And the nature of this lecture is on how to live within the contracts. So to get into a topic like this, we first have to understand what is a contract. And what is a contract based on? In order to live according to anything, you have to understand what it is you're living according to. And why, what constitutes it, what's the nature of it. Now when we deal with the nature of something, we're dealing with the origin of something. The beginning. So I'm going to go into the Black's Law Dictionary and define contract. Now understand that's a very broad word, because everything we do in life is based on contract. And all contracts make law. Everything is based on a covenant. So one of the definitions that the Black's Law 7th edition gives to the contract is as a noun: an agreement between two or more parties creating obligations that are enforceable or otherwise recognizable at law and binding contract. 2, the writing that sets forth such an agreement. A contract is valid if valid under the law of the residents of the party wishing to enforce the contract. The term contract has been used indifferently to refer to 3 different things: the series of operative acts by the parties resulting in new legal relations, the physical document executed by the parties as lasting evidence of their having performed the necessary operative acts, and also as operative fact in itself. The legal relations resulting from the operative acts, consisting of a right or rights in persona and their corresponding duties, accompanied by certain powers, privileges, and immunities. The sum of these legal relations is often called obligation. The present editor prefers to define contract in the sense: a contract is a promise or a set of promises, for breach of which the law gives a remedy, or the performance of which the law in some way recognizes a duty. This definition may not be entirely satisfactory, since it requires a subsequent definition of the circumstances under which the law does in fact attach legal obligation to promises. But if a definition were attempted which should cover these operative facts, it would require compressing the entire law relating to the formation of contracts in a single sentence. The term contract is also used by laypersons and lawyers alike to refer to a document in which the terms of a contract are written. Use of the word in the sense is by no means improper, so long as it clearly understood the rules of the law utilizing the concept. Contract rarely referred to the writing itself. Usually the reference it is to an agreement. Now, getting back to the nature of a contract. Some are enforceable by promise, by agreement between two parties, like it's specified. Some contracts are not in writing. It's never written. Certain productive or inalienable and substantive rights are not written. They're written as a reference. We use documentation agreed upon by the people as a reference to the covenant, but the nature of it is not written. Those are called inalienable rights. Common law rights. And those are the same rights that's protected and secured by international agreements, such as national constitutions, treaties, so when you get into a contract, the first thing we got to understand is where does it derive from and who agreed to it. Because the agreement equals acceptance, which binds the contract. So a contract has three separate components to it that makes it binding or valid. First thing to a contract is an offer. Means somebody has to present the terms and conditions of to whatever it is you're agreeing to. You can't agree to something that you don't have a demand for, that you don't have a remedy to say yes or no. You have to know the full terms and conditions of it in order to bind a contract. So you have an offer. Usually who makes the offer is called a creditor. And that's going into a commercial contract, but we got to understand where commercial contract is derived from. And it's all synonymous, so it's going to link up. Second part of a contract is acceptance. Second component of a contract. That's the agreement, which in modern day is a signature. signature usually binds the agreement part of it. Third part of the component is consideration. Consideration is the substance. As far as whatever we're trading, property, merchandise, money, Federal Reserve notes, whatever it is that you're agreeing as the subject matter of the contract is the consideration. So if I agree to buy your car for 500 Federal Reserve notes, then the 500 Federal Reserve notes is the consideration. Now that's what constitutes a contract. Now the second question is that contract valid or a legal contract or not? Because everything we do is based on a contract. Some type of agreement somewhere. And all contracts are enforceable. That's why they have tribunal systems put in place to enforce contracts. De jure or de facto, it's all based on contract. You have some contracts that's colorable. And you have some contracts that's de jure. One example of a de jure contract would be chapter 25 of the Holy Quran. That's an example of a de jure contract that has an offer in it, has acceptance, and it has substance, consideration. It has a result. You have certain de facto, another term illegal, another term adhesion contract. And if you go into the Black's Law Dictionary and just look up the word contract, you'll see 2 pages of different types of contracts. So if anyone has a Black's Law Dictionary, they can also go to that reference now, because I'm going to go and read a couple of definitions of a couple of them. You got a question?
Yes, I have a question. Would you have 3 parts to a contract?
Yes.
So would each part have to be done out of good faith in order for that contract to be conscionable? Because you have different types of contracts. You can have a conscionable contract, which is a contract done in good faith, or you can have an immoral contract, which is out of bad faith. So would you have to fulfill good faith out of each component of the contract, of the 3 components of the contract for it to be valid?
Yes.
Sure?
Yes. Yes. And that's a good point. And I was going to get into that. Out of any contract has or should be made, the agreement is based on a contract to be carried out in good faith. That is part of the agreement. That's part of the acceptance, is to carry it out in good faith. Now, you have the opposite of good faith, which is bad faith. That means that someone didn't carry out the contract, and their intentions of not carrying it out has a bad intent behind it. For whatever reason, the result is the same. Some people have different reasons for not carrying out a contract, but the result of it is the same. And this is where you get breach of contract, breach of duty, perjury. You have different levels or degrees of breach of contract, which is getting into the tort of a contract. And we're going to get into that also in a little bit. And you mentioned unconscionable contract, okay? Adhesion contract. And we have, you mentioned conscionable contract. And that's important because we get into contracts every day, and we have been entered into contracts before we was conscious enough to really know the terms and conditions of the contracts. Now, based on the definition of a contract, even those contracts that we might not have agreed to consciously, we're still liable for them, because there must be an offer, acceptance, and consideration somewhere. Even though we might not be conscious of it, whoever the presenter or the creditor or the one who run the offer of the contract expects that contract to be carried out in good faith, regardless if we knew the terms and conditions or not. That's what's expected. As far as publicly, privately, morally. Certain examples of that will be birth certificate, social security card, driver's license, passport, green cards, W-2 forms. All of those are contracts. I didn't say all of those was conscionable contracts or moral contracts, but they're contracts. Our job is to examine the nature of those contracts, especially if we knew that we was entered into them without our agreement, without knowing the terms and conditions of those contracts. It's up to us to examine those contracts, because some of them are not valid contracts. Some of them are not enforceable by law. One definition is adhesion contract. Adhesion contract is a standard form contract prepared by one party to be signed by the party in a weaker position, usually a consumer. Examine this now. Who has little choice about the terms. Also termed contract of adhesion. Some sets of trades and professional forms are extremely one-sided, grossly favoring one interest group against others, and are commonly referred to as contracts of adhesion, from weakness in bargaining positions, ignorance, or indifference. Unfavored parties are willing to enter transactions controlled by these lopsided legal documents. Everybody understand that? So, I mentioned in a contract you have the one who presents or makes the offer of a contract, term creditor. Then you have the one that's agreeing to the contract, that's agreeing to the offer. That person is usually in a weaker position. 9 times out of 10, that person is ignorant of the contract because that person didn't write the contract. They didn't make the offer. So they're either accepting some type of benefit, some type of de facto benefit, which means something that appears to be a benefit, but really is not a benefit. you have different considerations that will automatically null and void a contract if consciously it was understood what the consideration was. Now you had another question? Yes. Why would we rebut or disclaim that contract? I might can enter you into a contract that might be in the benefit of you and of your sovereign status without waiving any of your inalienable rights. We do it all the time for each other. It doesn't necessarily mean because someone entered me into a contract that it's a bad thing. Now I'm going to waive my sovereignty by being involved in that contract. If you were conscious when you entered me into it, will make a difference. Because that will determine my legal standing in that contract by what you did at the signing of that contract. Islam, brother, you had a question?